Sandra Strokoff, thank you so much for joining us.
Thank you for having me.
Why don't we start off with, sort of your career? Where did you start off? The arc of your roles over the years in Congress, and then what you're doing now.
Well, I was born and raised in Philadelphia at the peak of the baby boom. I was the third of four children born in 4.5 years. I'm a product of the public schools. I went to the Philadelphia High School for Girls, which is at the time one of only two public high schools for girls in the whole country. And from there, I went to the University of Pennsylvania and got a BA and majored in classics. And then I was awarded a Turin scholarship for study in Great Britain. So I got a master's degree at King's College, University of London in classics. Then I came back to the University of Pennsylvania Law School. And when it came to looking for jobs, I'd had experience with a law firm and I decided it wasn't for me. So I was looking around, and all I can say is the job at the Office of Legislative Counsel found me because they interviewed at Penn Law School and had never done so before. I didn't know the office existed. It drafts legislation for the whole House of Representatives. And they invited me for a second interview, and it sounded terrific. And I was offered the job, and that's where I spent my entire legal career. I was appointed by Speaker Pelosi by statute as the Legislative Counsel of the House of Representatives. Happened to be the first female. The office was created in 1918. We had our 100th anniversary a few years back, just pre-pandemic. And it was a marvelous, marvelous career. I wound up specializing in intellectual property, international relations, international trade law, ethics issues, and matters affecting the federal courts. And since then, I retired in 2016. I've been an adjunct professor at GW Law School since 2009. So I do some teaching there. And I'm a consultant, so anyone who wants to use my drafting services is welcome to do so. And I still do a little bit of drafting for the office as a consultant. There are a number of retirees, when the office gets into a bind, they just call us up and we just pitch in and help out. So that's how I got to where I am.
It's amazing, such a long stretch of time in the same office. And I think that it seems the Office of Legislative Counsel sort of shares that with the parliamentarian's office in terms of longstanding service. Is that right?
Yes. Well, it almost has to be because it takes so long to train someone to be a skilled legislative drafter. People don't really realize what goes into it. The Legislative Counsel at the time when I was hired, Ward Hussey, who was personally responsible for the Internal Revenue Code of 1954, brilliant guy, he testified in front of a committee that was looking at House institutions, and he said he thought it was about 8 years before people really hit their stride. And I found that, well, up until the day I was leaving, and even now when I have a drafting project, I'm always learning things. There's so many aspects to it that unless you have people who come and stay, it won't be efficient. It's not like getting a couple of years of experience and moving on. It just doesn't work that way. But yeah, I have enormous respect for the parliamentarians. I don't know how they keep all those rules in their head. And we have a great relationship. We consult with them all the time when there are rules issues, and they call us all the time with drafting issues. So, but both are nonpartisan by statute, and everyone has to be appointed without regard to political affiliation. We are bound by attorney-client privilege. We are not permitted to express any opinions as to policy, only to accurately reflect the policy in clear, concise legislative language, and that's in our statutory charter.
So, can you talk a little bit about the office itself? So what is it? Why does it exist? How many people work in it? And sort of what does it ultimately really do?
Okay, well, it was initially created as sort of an experiment back in 1918 and then established by statute in 1919, initially just to draft tax law. And the idea was to create a group of skilled drafters who would be responsible for drafting the statutes, the bills that the members wanted to put forward. The idea that that things are confidential and nonpartisan is very, very important, because the idea is that everyone, regardless of political party, feels comfortable coming to the office to get their legislation drafted, so that we'll get the best possible bill, and they won't, if they think someone has a particular political bent, they won't feel comfortable coming to the office. So just like the parliamentarians, we're very, very guarded. We don't hire anyone who has a strong political background. It just sort of, is in the forefront. It just won't work because of who we are and the service that we provide to all members at all stages of the legislative process. Now, our charter does specify, what our functions are and gives a priority. The first is to conferences. Bills in conference are at the final stage between the House and the Senate, and that has top priority. So that's what we've top priority that. Next are committee markups, committee business. Third is floor business. And then it says, upon request of any member, subject to such reasonable restrictions as the Legislative Council may impose with the approval of the Speaker on the proportion of the resources of the office which may be devoted to the request of any member to prepare drafts of legislation for individual members. Now, as it turns, we never turn anybody away, but there have been a lot of challenges over the years there are 435 members of Congress, there are 22 standing committees, and then on top of that, you have conference committees, and then you have, for a long time, there were about 35 staff members. It grew to 50 under my tenure. Now it's up to 56. But you constantly have to have people in the pipeline, and the people who are drafting are also the ones who are training the new attorneys. So we never turn anyone away, but sometimes some people have to wait a little longer for their drafts than others because of the priorities that are set forth in the statute. But you think about it, it's pretty amazing. I think Wade Blue, who's the current legislative counsel, sent me some statistics, and tens of thousands of drafts are produced every year for the members, and some of those will have multiple versions. So the volume is astounding. This is contrasted with a parliamentary system like the Brits have, where the leadership and the legislature are the same thing, and they only wind up drafting things they know that are going to become law.
So for the customer groups, you mentioned that there's the conference committees, then there's the committees, floor, and then regular members, right? That was kind of the hierarchy. Now, right. When you were in the role and working with these different kind of client groups, is that really the way that it was segmented in your mind, or is there other ways to kind of segment the basically customer?
I mean, supposedly you say, well, you do it in the order in which things come in, but as a practical matter, if you have some massive job you're working on, and then you might have an individual member job that comes in that won't take a lot of time, or that someone's been waiting for a while, or that you can ask someone else to handle. You want, and each attorney works differently, but if you're in the middle of a conference committee, that's what you'll be breathing, night and day. For example, the National Defense Authorization Bill, which passes every year, it involves at least a dozen attorneys in the Office of Legislative Counsel on each side in the House and the Senate, and it's a thousands of pages bill, and they have to comb through it and make sure it's accurate, because this is the last thing that's going to become law. So there really is very little time for anything else. But if you do have a breather, or it's in the middle of the night, or it's early in the morning, and you just want to get something off your plate, you will do it. But it's also a process. You get a job that comes in, you probably can't tell. It might just be now it's all by email. Initially, it used to be people calling up by phone or sending a memo back in the old days. And you'll get a request, but you really won't be able to tell a whole lot from it. So you want to call in the client, and it establishes a relationship. you ask initial questions and they may have to get back to you. And then I'm the kind of drafter, I start drafting and then more questions come up. You pull up, it's very much a back and forth. It's very little, well, I want this bill, do it. And then, very few are really like that.
Yeah, so that's actually a question I had about the skill level or the experience level or the level of detail that you get from your client, right? So maybe a committee really knows what they want. They can do 80% of the work versus a member comes along and they can do 1% of the work. They just have bullets about what they want in the legislation. How does that kind of break down in reality?
Well, even committee staff might have bullets. The beauty of developing expertise, which you all have to do as a legislative counsel, because there's just too many areas of law. So you develop expertise in multiple areas. You work with the committees repeatedly. You work with the staff people repeatedly. You develop relationships, and they know how you work with them and how they work with you. But they might call you up and say, I need this, and they'll give you a general idea of what they want. And that's enough for you to go on. A legislative counsel would probably not like to get sort of a full-blown draft, because then you have to try to guess from looking at the language what the policy is. And what's really important is knowing what the policy is so that the words can accurately reflect what the policy is. Nothing more, nothing less, no unintended consequences. What's the law involved? That's now you do this whole analysis before you even start writing. What's the problem? And you try to solve, because lots of times someone hears about a problem and a member think, well, there ought to be a law, and they want a bill to do it. And lots of times there's a law already on the books, and maybe it's not being enforced, or, maybe it's an enforcement issue, or the agency hasn't carried it out yet, or the problem is a particular regulation. You have to do all sorts of analysis like that. And then will there be unintended consequences if they try to change the law in one place? What will be the impact on some other law in another place? And that's another reason why you need to develop expertise, because you know that, you know where to look, and someone who hasn't done it before won't. And that's what's kind of terrifying when you first come in the office, because you're given a job to do and you work under the tutelage of a senior attorney, but you have to start somewhere, and it's a process, and you have to figure all this stuff out before you start writing, so you know what to write. So it's at all levels. You don't really know. It is true that probably individual staff for members tend to be younger and less experienced, and that might have to do with the attorney, the amount of money they have to hire people. I don't know how that all works. Committees develop more, of a core expert staff, because they have particular areas of law for which they're responsible. And it all happens, and everything has to come out of committee before it goes to the floor, for the most part. And that's where a lot of your work is involved. But we're involved in drafting at every stage of the process. An introduced bill, when it goes to committee, helping the committee come up with alternatives. When a member on a committee wants to offer an amendment, drafting that amendment for that member. Then when it goes to the floor, a member wants to offer a floor amendment, even if it winds up not being in order under the Rules Committee. I know Tom talked a lot about the impact of the Rules Committee deciding how something is debated on the floor. But that doesn't mean that our office won't draft hundreds of amendments, because members want to go before the Rules Committee to get their amendment made in order. We'll be drafting all of that. Then when you passes the House, passes the Senate, we'll work with our Senate colleagues in drafting the final version that goes to the president for signature or veto. So it's soup to nuts. I just found it fascinating. I just was never dull.
So can you talk me through the process, I guess, for any kind of bill or amendment? How would it go down? Someone comes to you, and it sounds like your ideal scenario is they come to you with bullets rather than the actual language, because it allows you to understand the policy better. So can you just
it depends. It depends, because sometimes when you get complete drafts, they may have been drafted by an outside group, and but our clients are the members. We're not permitted to deal with outside groups. They may send a draft down and the member wants to introduce this. So I start reading it, and let's say it's in some area like patent law, which is very arcane. I did patent law, copyright law, or trade law. It can be very complex. And I look at it and I would, and then you call the client and you have a series of questions. Well, they won't necessarily know the answer, so they'll want to bring in, they'll say, let me try to get answers for you. And then ultimately, you have to have this third, whoever drafted it involved, to answer questions so that I can understand what they're trying to resolve. But if it's an amendment, especially under time, where time is the biggest enemy we all have, and a bill gets reported out of committee on Thursday and the Rules Committee is going to take it up on Monday, then everyone wants their amendments drafted over the weekend. So they'll send something, usually email, and the member wants an amendment to do this or that. And a lot of them might be self-explanatory, like just strike this provision or just add this here. But you have to be careful, because if you modify something one place, will it have an impact another place in the bill? And part of your job is to clean up the debris, so to speak, and make it all work. So it can be a high pressure situation. So it can come in any number of ways. And the most important thing that I found is just having a dialogue with the client to figure out what is the policy, and making sure that what you draft is what the policy is. And that's the toughest part, and what they're really trying to do. Sometimes it's easy, just get rid of this, but it can be all over the place. So, and sometimes if you go back to the days when we were doing the healthcare legislation, you had the Energy and Commerce Committee, majority bill, minority bill. You have the Ways and Means Committee doing the Medicare parts and the Medicaid parts. And then you had, and the staff in our office was just working. They had boxes and boxes of amendments for committee, and individual members wanted their own health care reform bill. And eventually they would get it, but they would have to wait for it. So just because it's an individual member doesn't mean they don't want a really big mess of something or other. And we just, you do the best you can, the time constraints that you have.
So your first step then is to sit down with the client and try to understand what they really want to accomplish from a policy point of view. Then what's the next step?
Well, this is usually done by phone. So I would sit down and then I actually try to start to come up with the words, all right? And I may find out in doing that I see a problem in the law, or if I think about what they want to do, it might have unintended, or this might have this consequence down the road, or I might possibly see a constitutional issue, because you have to think about whether there's something or not. Under what power would Congress be acting to draft this legislation? Would it be its commerce power? Would it be its spending power? Big difference as to how far they can go. And in fact, so every time these questions come up, then I would call the person or shoot them an email. I was never a big email person, because it's so much easier to pick up the phone. What do you want to do about this? Then try to explain it in an email. So that's what I mean about a dialogue. And I think the younger generation is different, and I've been away from it for a while, but I always find it easier just to pick up the phone and just discuss it. And then, so once I get that answered, I'll sit down and continue to work, and then something else might come up. And then when I have a draft that I'm satisfied with, then I'll send the draft, but a discussion draft, and there might be brackets around it. What do you want to do about this? I'm suggesting this. You probably want to fill in this. You send it to them, and then they'll respond and come back. And, and may have to answer questions, and it's a back and forth. And then when you're both sort of satisfied with the final product, you prepare a version for introduction, and then the member signs it and drops it in the hopper.
So when you're dealing with the client in this way, do you have like a set checklist of questions that you kind of come up for each piece of legislation? So you already mentioned where does the power come from? That was kind of one. Another would be like the unintended, what are the unintended consequences of this? That would be.
I made a little checklist because I've done a PowerPoint on questions and drafting. And before you even before you even draft, first of all, why is the client seeking relief? What is it? What's the problem there? And what laws, if any, apply or are relevant to providing the relief? And you have to be aware of repeating the law, because if the law is already out there and you say the same thing again, a court's going to look at it, and under rules of statutory construction, they're going to know why Congress never would have enacted that if they weren't trying to do something different from the prior law. So that's a big no-no. Are there alternatives to legislation that could be pursued? For example, the one I mentioned earlier about enforcement. Enforcement of existing law. It might be a phone call, a member calling someone that, that's what the problem is. Are there related questions that arise with the proposed legislation? For example, if you're going to create a new entity, like a new agency, what powers are they going to have? Who's going to be, what are the personnel? How are they going to be compensated? Are they going to be able to have hearings regulations? What's the relationship to existing law? Are you going to shift powers? If you shift powers, then you have to change. There's all this debris in the law that you have to fix doing that way. Are there conflicts with existing law requiring collateral amendments? Are there any unintended consequences if the bill is enacted into law? And that's a big one if Congress acts too quickly. And I think one of the questions going to ask me down the road is, what makes good legislation and bad legislation, and it's having the time to think these things through, and not just the drafter, but the experts who would be carrying out the law and who deal with it on a daily basis. How will a bill take effect and be implemented? Will transition provisions be necessary if you're changing the rules of the game? If you're creating a new court or an additional federal court, well, how do you handle the existing cases, and what judges get transferred to this new division? This is a real simple example. If you're changing a term of a commissioner, well, what happens from 7 to 5 years? Well, what happens to the people who are in the 6th year of the date it takes effect? How do you deal with, these are implementation issues. Beware of drafting a public bill to fit only one person or circumstance, and that sometimes happens. And then it winds up affecting multiple people when it's only intended to. There are private relief bills, but they rarely pass, and a lot of people, you don't see too many of those. Will it be self-executing or rely on administrative discretion? So if it's a criminal law, it has to be self-executing. It has to be completely clear on its face because the constitutional requirements, you can't, something can't be made a crime unless it's absolutely clear what that is. And also ex post facto laws. How will the bill be organized? Who will the audience be? In most cases, it's usually administrative agency. How are there any parliamentary restrictions?
Well, I'd like to, before you move on, I'd like to talk a little bit more about the audience, because, you mentioned that the audience is the legislative agency here. Now, certainly there are a lot of bills in Congress that people would be calling messaging bills, where the audience definitely doesn't seem to be an agency. It's other members, it's primary voters, it's whatever. So can you talk about the different potential?
Well, the reason I said that, audience is when, any kind of regulatory bill, and probably most legislation, gives authority to like a Secretary of Transportation or Secretary of Homeland Security to do something, Secretary of Health and Human Services to do something. And that's, that's where the audience is. But it really can't be executed until the Secretary comes up with regulations to carry out the broad, direction of the law. And one thing that sometimes members struggle with is how much detail to put in the legislation and how much to leave to the administrator. If you had too much detail, then if you ever want to change anything, you have to have another enactment. I have some very funny examples of that, but, and sometimes if there are different parties in Congress than in the White House, Congress is reluctant to give too much discretion to the White House, but then if you don't do that, that can have dire consequences as well. If there's no out, a national security exemption or something like that, and that has led to some dire consequences on occasion too. That's what I mean by the audience. It's when it's an administrative bill. If it's a criminal bill, then the audience is every person. And message bills, yeah, a lot of members will introduce bills because they're representing their constituents and it's something their constituents want. And that's what was really surprising to our counterpart from the British Parliament was all the messaging bills and, all the legislation that members maybe won't go anywhere, but they introduce it or may reintroduce it every year because it's something they feel strongly about every Congress. Because every 2 years, because there's a Congress only lasts 2 years, I know Tom talked about this, it has to be reintroduced. You have to start all over again. The bills have to be, they all go away at the end of the Congress. So yeah, I mean, that's what there are different audiences, but I was talking about the regulatory bills thing. But of course, you want to draft something, and there's one school that says it should always be plain English. Well, the problem with plain English is it winds up sometimes not being precise enough to reflect the policy. And you can say it's nice to be, clarity is really important, but precision is essential, and it has to be completely accurate to reflect the policy and not do more than that. So, the kind of plain English, yes, don't use Latin words when English will do, but define your terms. So it has to be absolutely clear what every word, every comma is doing, every semicolon, what it means. So, the parliamentary restrictions, that's where the parliamentarian may come in because a member may be sitting on a committee and want a bill to be referred to the committee sitting on, even if it's not in the same subject areas. So you'll wind up putting a provision in that will wind up the bill being sequentially referred to that committee, although they won't be able to act on the operative provisions. But then it becomes very important committee, whether it's germane. Germaneness rules are important, and you can't offer a non-germane amendment, which is it's roughly equivalent to relevance in evidence terms. So there are rules of procedure that apply to how you conduct business in the committees on the floor. As I think, Tom discussed, you have these special rules that say this is how we're going to waive all the rules and this is how we're going to do everything. So you have to keep the parliamentary matters in your mind as well. And, under what constitutional authority will Congress be acting? What's the relationship with state law? Because sometimes there's a preemption issue, and lots of times, unfortunately, it's not specifically addressed. Then after all that, then you sit down and you write the bill. In order for any bill to be effective, you have to answer 4 questions. Who does it apply to? Who's going to administer it? How will it be enforced? And and when will the bill take effect? So these are we call the 4 prongs.
So it's interesting. The primary audience then is ultimately who has to execute the law, right? Or in the case of
obey the law. Yeah, I mean, yeah.
Right, or obey the law. So one way or the other, either who's going to execute the law or who's going to obey the law.
Well, okay, if I could just accepting in all the regulatory bills, you have the entire industries that are going to be affected by this. Very, very interested in the legislative, the legislative process as well, because they're ultimately going to be ones that have to comply with the regulations. So that's why you have so many armies of lobbyists hovering around in Congress because of the what we'll call interested parties. And it could be individuals, but when the directors are to these heads of agencies, they're the ones who are going to be carrying out the law.
So the secondary audiences then is quite interesting. One of them is the parliamentarian, as you mentioned, because the substance of the text will have procedural implications, right? So
they decide what committee the bills are referred to,
where it's referred to, right, and whether it's and the germane, right? So the content really has procedural, it's embedded in it, or some kinds of procedural rules. So you have the parliamentarian as a potential reader. Then you have, of course, all the special interests who may be interested in the text of that bill, whether it's messaging or whether it's substantive, right? Whether they think it's going to be in law or not. And then I think the other side is the judges, right? Ultimately have to interpret that law later.
Yeah.
So can you talk a little bit about when you're drafting, how are you thinking about the judges?
Well, it's interesting because when I first started out, rules of statutory construction were not emphasized at all. And you knew some general ones and some which wound up being not even 100% accurate. For example, everyone thinks that, well, if you have two laws and one is enacted in 2014 and another in 2016, the 2016 one rules regardless. And that's not true because the one in 2014 is more specific than the one in 2016 and the one in 2014. But over the years, the rules of jurisprudence changed so much, and the Supreme Court never, between 1937, I think, and 1995, I think it was, no Supreme Court ever said that Congress had exceeded its authority in passing a law, exceeding its constitutional authority. But then starting in the 90s, there was this line of cases that narrowed the Commerce authority and then started to put limits on the spending authority because the Constitution says those things that aren't specifically reserved for the Congress are reserved for the states, unless it's specifically given to Congress, reserved for the states. But the spending authorities, Congress says Congress will try to put restrictions, try to regulate things through money that it can't regulate directly. And then, of course, the big case that came down on the Affordable Care Act finally put in outside limits saying that, this individual mandate exceeded Congress's authority, regulatory authority. And the Medicaid restriction says unless states accept all these Medicaid changes, they're going to lose all their funding. They said that was equivalent to putting a gun to the head. You can't do that. So you really do have to pay attention now to how far a bill can go. I wrote it, a colleague of mine wrote a book about drafting in 1990s, and then I wrote a second edition in 2007, and I decided to add a chapter on rules of statutory construction, and it was like a revelation to me. I mean, how, of course, they're sort of picking these rules out of the air, and I guess they figure they have to. But I actually have an example in the book of two Court of Appeals who came to opposite decisions on the same law, applying two different rules of statutory construction. So, so some cynics may say, well, they picked the rule of statutory construction, they know how they want to come out, and they find one. But there are some that they do, and one is that rule against surplusage. If Congress says X in one place and X plus Y someplace else, then there has to be a reason to do it. But you can't even use that anymore because the Affordable Care Act was just such a mess. And even the court recognized that it was a mess, and some things had to go by the wayside. So it's really, I mean, that law and how it became law, and then the subsequent court cases, it's just fascinating. It's fascinating from all sorts of perspectives. I think when this case is rough, the legislative councils were chewing their nails, wondering how the cases were going to come out.
So it's interesting. So we talked about the different audiences and, what's kind of going through your mind when you start to draft it, and who, in terms of when it's done, you've drafted it, you've put it into its special format or whatever. Is it over then, or does it come back to you? Do other people come to you and say, hey, I don't get, what does this bill mean? Or do they go to the source, or, what happens after that?
Okay, it gets introduced and it's referred to a committee. Now, if the committee takes it up, then it becomes, the committee may hold hearings on it, call in experts. The committee may have scheduled a markup. If the committee schedules a markup on it, where they're going to consider it, then they usually come to whoever the drafter is. And usually both the majority and the minority will want substitutes. They'll hold hearings, and the hearings will show some flaws in the introduced bill, and they'll want to fix those. So it usually winds up being like a complete substitute, which the chairman offers at the meeting, and then the minority may have its own substitute for, but then individual members may want to offer amendments. to perfecting amendments for their own particular interests. So you wind up drafting all of that, and you attend the committee markup, and things may come up with the markup, and that's why you're there. And then at the end of that, our office puts together the bill as amended and the report materials, and it shows the bill as, the changes in existing law that would be made by the bill if enacted into law. And that's reported to the full House. And then if the full House takes it up, then we draft amendments for the Rules Committee, for individual members to offer the Rules Committee. So, yeah, you follow it all the way through.
And so you actually sit in the markup meetings. You're part of it.
Yes.
And
because things can come up, yeah.
And what do you do?
You also want to follow it.
Are they asking questions, or are you taking notes? How does that whole?
Well, it's debate. So members will offer amendments, and then they debate it, and then they vote on the amendments, and that can go on for some time. Sometimes an issue comes up, and in the course of the debate, and it'll come to you, I want an amendment to amend this amendment to do X or Y, and does this work? And sometimes it's scribbled on a piece of paper or whatnot. So it's important to be there, and also because you're the one that's going to be responsible for putting together the final document, and so you want to follow everything that's going on. So, yeah, you're there to follow the debate. And some of it, I went to all the, since I did intellectual property and court stuff, I went to the Judiciary Committee, and some of the debates were just fascinating, because they're all lawyers. The one downside is every lawyer thinks they know how to draft legislation, so they're trying to draft their own amendments. But on the upside, some of the debates were just fascinating.
And at this, for that kind of a bill, you have such a deep knowledge of it. Are you a substantive member of the debate at that time? Or they say, if I make this change, what are the consequences? And then they ask you. Or are you just kind of more of a fly on the wall, taking it all?
Yeah, it's more as a fly. Way, way, way long ago, I did a lot of drafting for the Foreign Affairs Committee, and I got called on a few times to explain what I thought something did. But we even stopped doing that because that became political. You say it does this, and and sometimes, and even when I used to be on the House floor, we'll get to that later. Why you really don't have to be on the House floor anymore. Whenever it came down to a vote, they'd be debating it, and normally we sit at the majority table in case you needed, to draft an amendment or something. But when it came to the vote, I would just go to the back of the room because members would come to me and say, "Is this a good idea?" And I say, "Well, legislative counsel." And they say, "Well, I know that, but is this a good idea?" And I said, "Well, no, we can't." So ultimately, I just kind of go to the back of the room because it's not my job, or, I never feel comfortable saying it's a good or bad idea. And, the staff people they're the ones that are supposed to talk to the members when it comes to, how they're, if they haven't made up their mind how to vote. Because the number of people, members watch it on TV back in their offices, but the number of bodies on the floor for debate is just a few, and they all come for the vote at the end.
So then when it's on the floor, I guess, obviously that's something that's changed over time, but in theory, what was your role on the floor then for legislation? You've already been in both steps before that. Now it's on the floor. What happens?
Well, nowadays it's just the pressure is drafting all the amendments for the Rules Committee, because the Rules Committee then comes up with a rule and they decide which amendments are in order. And the rule will always say, this member may offer this amendment printed in the report on this page, and no amendments may be, you cannot offer any amendment to this amendment. Normally under normal rules of procedure, you can offer an amendment. You can offer an amendment to that amendment. You can offer a substitute for that amendment. You can offer an amendment to the substitute called amendment tree. You can't do that because of everything the way it's been scripted in the rule. The one exception are appropriations bills, and I can go with that. They have a whole different set of rules, and any member can get up and offer an amendment. But the rules for germaneness on appropriations amendments are so strict that almost nothing is in order. So since you don't have control, and you're not needed to really draft, and even if you were, with the computers, the advent of computers and emailing, you could just draft. It's easier to draft it back in your office and just send it to them. because that, something did come up, you could just stay in your office and do it. The one exception being that the minority always has, after a vote has occurred on the amendment, which is in front of, the previous question, which is voting on the bill, then the minority has the absolute right to offer one motion to recommit, which is a motion to take, and it's a way they can get an amendment voted on. And that's where legislative counsel would be needed to help draft those motions to recommit. And some members of the office would go down for that. Others would just, like now, would just draft it in the office and then send it to them. And if there's an issue, you can just quickly amend it and then send it to them again. So because of technology, there's also a reason not to. But back in the days when you used to scribble things. And the other thing was they had a lot more open rules. When I first started, the bills were much more one single subject bills, and they're much shorter. They had open rules, so anyone could offer an amendment. And you were drafting things on the floor. You're drafting amendments to amendments, substitutes, converting, and that kind of thing. So you could be really busy. That doesn't happen anymore.
So you're also drafting the rules then. So you're drafting the bill, then you're drafting the rules to that will govern the bill on the floor.
No. That's the rules committee.
Okay, so
Totally the rules. Yeah, that's totally the rules committee. They draft their rules. It's and I think Tom talked about how politically it's much more majority minority than other committees.
So you actually you don't touch any of the rule, because I was going to say that sounds like overlap between your role and the parliamentarians or
No. The rules committee drafts that, because they're making the decisions and they hold the hearings. Members want to be heard about why they want their amendment offered, and they make those decisions and they do that printing and stuff. That's totally the rules committee. We're not involved in that at all. Really political process.
So you write all these amendments, et cetera, and the bill itself, the markup, you're involved in that part. And then it gets passed, say, it goes over to Senate, and then it comes back again.
Well, there could be a conference committee between the two houses where the House appoints members and Senate appoints members, and they meet to resolve their differences. There are very few conferences. Another way to do it is bouncing it back between the House and the Senate. So there might be a House bill that goes to the Senate. The Senate strikes all after enactment clause, and they tack on their amendment. That goes back to the House. Now, at that point, the two houses are negotiating to try to reach a common text that all can pass. And that's something that we'll be working on with our Senate counterparts, as if it were a conference, because you're still, you're trying to work on text that both houses will pass and eventually come up with that. And it'll be in an amendment form. So the House will then have an amendment to the Senate amendment that everyone's agreed to. They'll pass it, then the Senate will pass it, and that's what will go to the president if everything goes smoothly. But that's a lot easier than convening a conference committee, and then there's a whole level of rules and paperwork if you're doing a conference committee. They do happen. They always happen on the defense bills, but they're procedurally they're difficult, and then of course you have to run around to get signatures because a certain number of members and senators have to sign the signature sheets in order for it to be legal, and then so they go chasing them around, in the middle of the night trying to find somebody to sign a signature sheet. And you don't have to do that if it's bouncing back and forth between the two houses.
And so for the drafting side, how do you work with the Senate drafters? Or is it, are you all going out to dinner together and making things happen? Or is it more like, we're not, where things are.
Well, we're working as if they're our colleagues. And I mean, so you work with the specialists over there, and about my very best friend now, someone I worked with in trade legislation for 20 years. And it becomes a necessity, and you just develop relationships with the experts over there, and you just work together. And again, like anything else, you have a better product when you have more experts working on it. And, sometimes you have time to proofread everything as much as you want, but, you divide it up. You take Title I, I'll take Title II, because some of the bills will just be so massive. So you either work on the House side or the Senate side. And some of it may depend on which house is going to act first. There's rules of procedure to decide who which house acts first, and then they need the papers first to pass before they send it over to the other house. But yeah, you just, you work with your colleagues and you develop relationships with them, just like with your colleagues in your own office.
So when we're talking about this whole process in the office of 50 plus attorneys, right, are all working to draft, what kind of tools did you use? Is it everyone's using Microsoft Word, or when you started, was it there's proprietary
Well, first of all, there wasn't Microsoft Word. when I first started, believe it or not, they had one master copy, and the clerks would cut and paste everything. So you had one master document, and every time there was an amendment, they type it out on an electric typewriter, they paste it in, and that'd be the master document.
Wow.
That's what they would make copies of, and people would come and pick them up. As I said, we introduced computers in the early 80s, and first we shared them, and and it was just as the technology developed. I don't even know when we started, and we obviously at that point we learned DOS. We learned how to do the bills, with the DOS commands, and then we very slowly got into XML, because we also wanted a common language we could. I guess someone just decided they wanted I don't know what you call it. It's a menu program as opposed to DOS. I don't know. So that all that, but it took so many years to get it without bugs, and there's still always bugs. It blows my mind, and all these developers were involved. It just was so complex.
So this is a proprietary software that was developed for the office then, is that right? The software you're describing right now?
Yeah, well, accepting that, government can't own copyright. I mean, it was of necessity, but it's not something like an individual member's office can stick in and know how to use. I mean, XML, again, is a product that you can get off the shelf. This was specialized to meet our needs, but it's actually, I'm not even sure how the intellectual property works. I know the government can't, but the government pays them for it. So I would have to look into that. I don't even remember anymore.
But what does the software do that a typical word processor wouldn't do? Is it have some special features or functions?
Well, yeah. I mean, first of all, aside from knowing, when to indent or what to indent or what to call it, there are a lot of commands. I mean, I would actually almost have to be in the program and show you the level of complexity, because you just wouldn't believe it otherwise. But whenever, working as a contractor, I've had to work in Word, and I hate it because it's always trying to make decisions for me, and you want things to be lined up in a certain way, and it just won't follow it, and then just paragraph it the wrong way. And it's just the way that legislation is written. It just doesn't do the way Word wants to do it, and then the fonts and everything.
So it's mainly formatting and font. It's not
right.
Not in terms of like referencing or comparing legislation to other legislation. It's not like analytical functions. It sounds like more of a formatting.
Well, for the bills, yeah. I'm pretty sure now they're working on other tools that would allow like staff members. We started on that like when I was still in Legislative Counsel, to be able to execute something that would show what the change, just do redlining existing law. The problem with a lot of the programs that are outside the government is they don't accurately reflect what the law actually is. And I'd have to go into a whole hour-long lesson on the difference between positive and non-positive law. But the Office of Legislative Counsel puts together accurate reflections of each law as of today, reflecting all the changes in the law. And now that database is now available to everybody at the gov.info. But I mean, most people just think you can just go into the U.S. code and it doesn't matter what title you're in, and you can just amend that, and then that's how you change the law. And it's not true at all. It's not an accurate reflection of the law unless it's been enacted by Congress. So, I know that doesn't make a lot of sense, but it doesn't. It's the hardest thing to teach law students too.
So it sounds like this software was really more of a formatting kind of thing. What tools, did you wish you had in that position? Were there things that you dreamed about, like if I could search the code or connect to the existing code properly or do X,
well,
Y?
well, that's interesting because the Law Revision Council, they're the ones that actually keep the U.S. Code totally up to date. They were like in another century, and you couldn't just go in and lift text out and do that kind of stuff. Well, they finally went into an XML format, so now anyone can go on and you can lift text out. And they have tools on their website where you can find all references. If you want to change something in a section here, you can find every reference to that section in the U.S. Code. There are all sorts of tools now you can use, in the U.S. Code, and all sorts of tables that are very, that are very useful when you need an issue of, a constitutional issue. You call a Congressional Research Service. There are all sorts of budgetary questions that come up, and that's where CBO comes in or the budget committee comes in. So there are all sorts of, support offices out there. But yeah, the U.S. Code, the uscode.house.gov is an incredible website that anyone can get on, and has all sorts of useful notes. But the thing that's still hard to get is like instant redlining if you have a bill. And it makes amendments to law, pushing a button and showing those changes to existing law. That would be in that particular version. And maybe that they have that tool. They sort of had it when it wasn't 100% when I retired, but that's something that's very useful to members and staff because bills are hard to understand when they just cut and bite. This section is amended by striking and inserting or, you have no idea what the context is. So that kind of tool that would be, really, really accurate is essential. And that's how state legislatures operate. They sort of reenact all the law and they show all the changes, and that's how they vote on it. If you did that at the federal level, you'd have millions of pages in the U.S. Code instead of just thousands and thousands and thousands. So.
Right. So let's move on to the concept of what I would call good or bad legislation, right? So as a drafter, you've spent an incredible amount of time writing legislation. Over the years, have you thought about what, from a drafter's point of view, right? What is a good or bad piece of legislation?
Well, from a drafter, the answer is easy. I mean, if you're given enough time to think it through, to come up with the language which only does what you want it to do, that deals with unintended consequences. If you're given enough time to think through all those steps and then read it and proofread it, and then come up with a piece of legislation that really winds up not having unintended consequences because you have the time to do it right. I mean, the subject matter doesn't really matter. It's if what you came up with accurately reflected what the objective was and did it precisely. I mean, that's what the drafter wants.
So what do you mean when you say unintended consequences? Because I can imagine different ways to view that problem. You can have the unintended consequence of, I passed this law and it actually conflicts with another law, in the code, or I could have a different unintended consequences. It doesn't solve the problem that was originally thought about, right? That was trying to be addressed, or, it could cause a war in some third country that nobody had intended. So when you say unintended consequences, do you mean the first one is more of like a logical consistency with the code, or do you mean outcomes?
Well, it could mean any of those things. I mean, the World War thing's kind of far-fetched, but I mean, you take, for example, the easy one, the Affordable Care Act, because the Senate passed it and then Senator Kennedy passed away. They lost their 60-vote majority, so the House had to take the Senate bill or nothing. So they take the Senate bill, which is a complete mess. And one of the questions is they talk about whether the tax breaks can, will be available to people who sign up in states that have federal exchanges and not state exchanges, because the language said, you're eligible if you are a member of an exchange established by a state. And then the question is, does state mean federal? And is federal? And that was the basis for the whole case. And that happened because it was intended to be fixed in conference. You had the tax drafters over there, and they're just saying established by a state. They didn't know that the energy drafters over there were talking about establishing in the federal exchanges. And that's how that happened. And then it wound up being a Supreme Court case. And that's because there was no opportunity to fix these issues in conference. If there's not enough time to read it and proofread it, I mean, the more you think about something, the more things you think of. If you forget to put a comma in, and then it winds up not being an Oxford comma, and then it winds up having an ambiguous result. I mean, the ambiguity is the bane of the drafter's existence. And the less time you have for something, the more opportunity there is for things to happen that no one was thinking of. They're just thinking of this problem, and you got to get it done right away. So you come up with the words you think that'll do it, but not enough people have looked at it. The experts haven't looked at it. There have been no hearings on it. So these issues haven't had time to come to light. It's really a time issue, and time and having, enough eyes looking at every single issue.
So it sounds to me like what you're describing is one measure is time, right? Time of the drafter. And that's sort of that's a proxy to thoroughness, right? And being thorough in terms of thinking through the logical consequences, the unintended consequences, all the logical consistency, I should say, and then with the existing law and its internal consistency, and then all these other unintended consequences. There's that kind of element of the goodness or badness of a piece of legislation. And then on the other side, you just mentioned, is it thoroughly vetted in committee? Do you have experts? This is kind of another layer of scrutiny or information creation around a bill, either positive or negative, where the drafter and I guess presumably the members are getting information from outside sources on that bill. And you think that's also, the more of that expertise you get from the outside, that would equate to a better bill. Is that right?
Well, to me, that's the legislative process. And sometimes you'd be in a situation where, as a staff person would ask, well, what do you think, would be the impact of this or whatever? And I say, well, have you talked to the agencies about this? They're the ones, the agencies or whoever's going to be implementing the law, they're the practical experts, and they really know what's going on. We can't foresee all this stuff. We can know the law and know where to look in the law, but we don't implement it. And that's the process. So a committee is referred a bill. If they're going to take it up, they should hold hearings on it and bring in experts. I know they choose the experts, but get testimony about what should be fixed. And the more technical the bill, the more that's necessary. The more technical bill, the more you really want more experts looking at it and giving input. Because otherwise, you can ask a question and nobody knows the answer. So it's getting as many experts as possible involved in legislation is always going to be a good thing from many different viewpoints. That said, sometimes it comes down to something in a political situation. Words are chosen because that's the word that gets a compromise among all the parties. It may not be the best word, but that's what has to be done to achieve a compromise. And that's another element too. That's the political side. But, legislative counsel just wants to be in the room, because even when they're discussing these things, then you can raise questions. If you do this might be and that's the advantage of having a legislative counsel in the room. At that stage, but any kind of drafting stage, you don't want to be presented with a fait accompli. Well, this is the language was decided. You can't change it, and that's a way to kind of be railroaded too. And may come down to time, or time's always the enemy. And I don't think enough people appreciate how much time is required to think things through. You can't just push a button, Control-D, and then you have a bill and it all looks pretty and all the problems are solved. You have to think about that stuff before so you know what to input. After you do Control-D and the form comes up, you have to know. So that was always a frustration. And sometimes I think that philosophical, I think it's the computer age, and I see how quickly things, keep going, the changes that I've seen. And I think everyone just expects everything to move super fast because computers move super fast. So my own 2 cents.
So what about the notion of complexity? Because obviously, I guess I think about this in 2 ways. One is I think about an ever-growing body of rules for society, creates more complexity, which by itself might be a bad thing. Once it exceeds a certain level, who knows when it already exceeded or if it ever will exceed that level. And I would think that might be something that would come into the drafter's mind, right? You can draft something that's 5 pages long to achieve something that could be achieved with 1 page, or there's a set of things that could be done in a shorter period, more concise way than others. Does that ever enter your mind as something that would be good or bad when it comes to a bill? Is that something?
Well, drafter is always trying to figure out the way to say something, in the fewest words that doesn't have unintended consequences. You try to be concise. I mean, and if it goes on for pages and pages, chances are you're using words that are unnecessary. So you're always trying to be concise. The policy may make it go on for 5 pages because it's not a concise policy and you can't express it in 1 sentence. But the drafter's goal is always to be concise, but you can't give up precision to be concise. So if you have 5 little different subsets in the policy, you have to deal with all of those subsets. You can't just not deal with them if that's what the policy is. And I'm obviously see that in the tax code. But that's why everyone needs tax accountants and tax lawyers. And now laws are really very, very difficult to fathom, but a lot of them too are from another era. In the 1980s, both offices of Legislative Counsel, House and Senate adopted a uniform way of drafting to try to simplify things and make sure there were headings for everything, so you at least had a clue about what the paragraph was about. You look at old laws and they're just kind of in prose and written out, and sometimes hard to fathom what the relationships are between them. That's another good way to achieve clarity is, and if you read something and you can't think of a heading to match what you're describing in the paragraph, then it really is more than 1 thought, so it should be 2 paragraphs. So, these are always things that are going through the drafter's mind, to be as clear and concise as possible and only deal with like 1 subject thing at a time.
Yeah, I think that's interesting when you compare legislation to something like a patent, right? Where a patent, you have individual claims where the claim really defines, in that case, what the patent is protecting. And a patent examiner can strike a claim, say it's not, it's not novel or what have you, or important enough, et cetera. So whereas in legislation, it sounds like you're kind of freer to put things wherever you want, and that you've tried to impose some kind of logic on that by breaking it into paragraphs. But ultimately, there isn't that kind of core, I guess you would call it like a quantum of legislation or a particular rule or a particular, the smallest unit is in your mind more like the paragraph, but hard to really get that as a separate issue.
Well, no, that's not really true because I didn't get to the organization. You like always try to have important provisions before less important ones. You have your general rules and then you have your exceptions, and then you might have special rules. Put your definitions up front so people know when you start using terms what they mean. Your collateral amendments you put towards the end because they're the sort of cleaning up the debris that's left when you make your changes here. But you always want your main message up front. And that can be divided. I mean, you call things different things. There's sections, subsections, paragraphs, subparagraphs, clauses, subclauses. And then if you go below that, you probably should rethink it because there's probably additional thoughts. But the organization is pretty fairly standard. The problem comes in where you go into an old or arcane law and then you're carving out something and you have to find a space for it. But it's still got to be drafted as a unit, just one thought, or if it has one thought and then it has exceptions that'll come right after the one thought. And then, so you still want to follow the same general rules of organization.
It's interesting. You've used the word debris a few times. Can you explain what is legislative debris?
Well, okay. I mean, I probably shouldn't say that, but let's say it's a real simple example. Let's say you have a section that has 5 subsections, A, B, C, D, E. And you're going in and you're striking subsection C. So the way you do that, you say section 1 of the blankety blank act is amended by striking subsection C and redesignating subsections D and E as subsections C and D respectively. Okay, so you're getting rid of the middle one and then you're pumping this up. Well, farther down in the law, there are references to the section 1C that you've stricken in your first section. So you have to go in those other sections and get rid of it there. Or the references to D and E, which are now C and D, you have to go in there and redesignate, it's consistency. It's a consistency thing. And major problems arise when time is not taken to do technical amendments. A really, really big example of that was the Homeland Security Act. There was a real push to establish a Department of Homeland Security in 2002. So the bill passed, but it moved all these functions from various agencies to this Department of Homeland Security, in some cases bifurcating them. So Secretary of Treasury had all the functions relating to imports. About half of those were then taken from Treasury and moved to the Department of Homeland Security. But the law that originally gave the Treasury was never amended to reflect that. So you look at the current law and say, well, this is Secretary of Treasury, but in reality, it's not Department of Homeland Security. So it just, the law was never changed to reflect what the law is. So it's challenging. That's why technical amendments are so important.
And is there some kind of cleanup that needs to be done in the U.S. law? Like, should there be a committee to clean up the debris in the U.S. code?
Well, I mean, it always comes down to a matter of time. And all I can say is, and again, I've been away for a few years, and I don't think things have gotten less partisan, but at the time, towards the end of my tenure, things had gotten so partisan that it used to be that after a bill passed, there'd be little technical changes and that needed to be made, and they just do something called a concurrent resolution that would pass both the House and the Senate. That'd be it. Where they correct in the enrollment, they'd make this strike B and insert C and do all that. Things became so partisan that agreement could not be reached to even allow that to come to the floor. So those technical amendments aren't even made, and there are likely to be notes in the U.S. code when there are errors like that. So at least the reader might have an indication, but not. Like what I just talked about, the Secretary of Treasury, you just would be totally clueless looking at the, at the Trade Act, the Tariff Act of 1930, and have any idea that the Department of Homeland Security is now involved. So it's, it's challenging. And like anything else, it comes down to time, but also political will to do it.
Well, so that sort of leads to the question about what's changed over time, right? You've already mentioned a few things, but when you look back on the changes when you started in the office, compared to when you left or even now, what do you see has changed over time, for good or for ill in that area?
Well, I mean, what I talked about was sort of the fact that general debate really doesn't happen much on the floor anymore, except for appropriations bills. So what it does happen is in committee and committee. So that's when you really do have full debate and any member offer their amendment and then the rules apply and that sort of thing. So if you don't have that full debate on the floor, so, obviously some things, depending on your point of view, maybe some issues get missed or are not fully debated, except for the fact that someone might oppose something or whatnot. Bills were shorter. You have mega bills now. And with mega bills, at least with legislative councils, if they're all draft in the same style, you can have more than one drafter work on the same bill and it'll kind of look the same. Well, the technology obviously has changed dramatically. No longer cut and paste, but and the tools, keep advancing. We're all we became affected by the partisanship, even in a nonpartisan office, and it's you just have to be affected by what goes on outside. You're accepting inside the office. It was always a pleasure to work because politics never came into it. So. And we always thought we were funny. We make each other laugh. But it was always an incredibly collegial place to work.
It sounds like the hours were irregular if you were working at night. So was that the case in the beginning, and is it still the case now?
Well, even the beginning, I remember, it was unpredictable. And then back then, of course, we didn't have laptops at home. It wasn't until after 9/11 that we all got laptops and started working from home. And then, of course, it was a long time before we had the right, they only had like 2 phone lines to call in. This is during when the anthrax, right? So everyone was home and we're trying to call in and you had to wait, But now, one incredibly nice development, if there wasn't anything good that came out of the pandemic, is that people could work from home and very accurately from home. And now they use team meeting, this kind of technology, and it's just dramatically changed things. So now there are some people who have to move because of spouses' jobs or whatnot, and now they can continue to work for the office because they can work remotely. So being able to work remotely has been a huge asset. And the only downside is, of course, this happened as soon as BlackBerrys came out, is that everyone expects you to be available 24/7. You start ding, on the weekend. And, but it tends to only happen during peak times, but it can be unpredictable. And when you only have a staff of, 50 some and you have, crunch times, it can be difficult for some. But, hopefully everyone manages to get some downtime. So but you have to be able to, it's just important to be able to train the people to draft and get them to stay in the office because of the expertise that we can provide.
Yeah, I think the tenure seems quite important for that office and for the parliamentarian as well. Parliamentarian, yeah. So I guess last question about the legislative drafting process. If I'm a member and I've got some policy idea, what's your advice to me if I'm coming to the office? How should I get prepared so that I can be maximally effective?
Well, first of all, we like almost never deal with members. It's always a staff person who comes down with a proposal.
So prepare your staff member well. So how would I prepare my staff member to go talk to you?
Well, the member's going to have an idea, and then they're going to say, just probably tell the staff person, go do it. And if the staff person is new, my boss wants a bill to do X, and you get it, then you can call them up and start asking them questions. And they may or may not have the answer. And then, if they really need to know more about it, we may refer them to the Library of Congress, Congressional Research Service, which we do a lot. They'll have experts who will they're amazing there. You need some help with any topic in the world, and then they'll come up with it. So it's a back and forth, and sometimes you get new staffers or summer interns, and they'll come with their job and they'll say, my boss wants this and he wants it by 5 o'clock or something like that. So there's an education level involved, depending on what it is that they want. So, it's an education, and the education comes out by simply the questions you ask when someone comes with a proposal. Do you want to do that? Or do you want to do this? what about this law that's already in the books? What about this, and just they have to answer the questions because you can't. Or they might say, well, what's the standard? What's the standard? You say, well, there isn't a standard. How much time do you want to give them for the regulations? It's educate. You wind up having to educate any new staff person, but they catch on pretty quickly. And now I understand that they actually are offering classes to new staff on how to deal with legislative and work most effectively with legislative counsel. And that must be really, especially if they can do it, remotely. That must be a great help.
Great. Well, I think it's time for us to move on to the common questions I ask all the guests.
These are afraid of.
That we can compare these. So are you ready to move on?
Sure.
All right. This question is a personal question here. So what do you think congressional representation should mean? Does a member represent their whole district, just the primary voters, just the majority voters? Do they represent the past, the present, the future?
Well, to me, a representative in Congress has to represent, they're representing the people in their district. But, they were elected by a majority, presumably, but they're supposed to represent all their constituents. That's how I view representative government. Not to do that is what leads to extreme partisanship. And that's an effective congressperson to me, would representing the interests of all our constituents and have enough, and as like my member does, have town meetings and have enough of contact with the people so they know what's going on and have, ways of, I'm sure that they will email and that kind of thing, but he actually has town meetings too.
And what about their role as either reflecting the aggregate views of their constituents versus making their own judgments about what they think is in the best interests of the constituents?
Well, I think you elect them to represent you, and they're not going to canvass everyone by plebiscite about how I should vote on this or that. They kind of exercise their judgment. Presumably, it's based on the wants of their constituents, but I think the one shame, if there's a shame about the House of Representatives versus Senate, is that they're only in for 2 years, and it seems like as soon as they're elected, they have to start campaigning for the next election. So you just worry that not enough time is spent on governing as opposed to campaigning. But since I'm not involved in that at all, in the political side of things. But you're right. You're right. They do vote on things that will have impact beyond the 2 years. But then but Congress can always change the law, and the law is frozen in stone. And if something happens and the law needs to be changed, then the law will be changed. It's not meant to be static.
But it sounds like you think that the representatives should be making judgments rather than as a window into the views of the constituents.
Well, maybe I don't understand the question, because, you're electing them probably for their judgment. You're electing because you think they will represent you in the best possible way. So then, that's why you're electing them. So you are relying upon their judgment to some extent, but they're still supposed to listen to you. But each member represents at least 550,000 or 575,000 people. So they're not going to be representing views of everyone. We all know that. So, but I'm not someone who would ever want to be a politician.
So next question is, how would your ideal Congress allocate its time? So would you have them work 40 hours a week all year long in legislative and oversight work? Would you let them be half-time? Is it 2 weeks on, 1 week off? What are your thoughts on their work schedule?
Sometimes I think maybe not enough time is spent because of these issues I've talked about. Maybe on some of these issues, more deliberations could be made, like at the committee level, and more hearings, and get more input from experts. Again, the whole time thing. If more time is put into each piece of legislation, then maybe that produces a better product. how that translates, into time. And I don't know, and I have been around for several years, but flying out on Thursday and coming back on Tuesday, maybe it also impacts how well they get to know their fellow Congress people. I don't know. If members of Congress in particular, they always have spent a lot of time campaigning, and I'm really not qualified to answer that question. All I can say is that it would be nice if more time went into deliberation of each piece of legislation, starting at the committee level, which is where probably most of it happens anyhow, before it gets to the floor.
So that leads into the next question, which is how should debate, deliberation, or dialogue occur or be structured in Congress? And it's interesting because you've been at, obviously so many markup meetings and where some of this give and take is happening. So where should it happen?
It would be nice. It would be nice if more of it happened on the floor. If it doesn't become, with I guess with limits, if it could be more open debate with limits. If an amendment is debated and then in the course of debate, some legitimate questions come up, maybe it'd be nice if it would be possible to amend that on the floor. And I don't know, I imagine they could do it by unanimous consent. Maybe sometimes they do it by unanimous consent. But in committee, a lot of that happens. An amendment is offered and could be modified because a certain issue comes up, and then the member who offered it didn't think of that, so then they're happy to accept the modification of their amendment. So, as I, in the beginning, most of the bills I worked on had open rules, and that's how it happened on the floor, and it just doesn't seem to anymore. I certainly wouldn't want the process in committees to be cut back, because at least there is open debate on the committee level.
So you want some kind of open rule, at least within limits, on the floor, and you want more action in committee. What about the role of transparency? Were you in markups or debates or dialogue where it's closed to the public or when it's open? And did you see anything?
No, it was always open. And now I think they televise them all, I think. So, yeah. I didn't have security clearance. I didn't want any. But so I didn't do anything on the intelligence committee or anything like that. So I was only involved in open meetings. There will always be standing room only, people trying to get in from the outside.
Right.
Especially if there's copyrights involved.
All right. Well, the next question is, what fundamental institutional improvement should Congress make within 50 years?
Without amending the Constitution?
Without amending the Constitution. It has to be internal.
Yeah. I don't know that things are going to become less transparent because of the way, things work and everything seems to be broadcast. I guess I really don't know how to answer that question other than to reiterate what I've already said about trying to have, maybe more open debate on the floor. I guess I need more time to think about that. Congress. And I can't speak for the Senate. No.
What about in terms of the rules? Not in terms of rules, in terms of the drafting process. If you could, would you double the staff size? Would you invest in a bunch of technology? Would you?
I think there is, and the current legislative council is he's hiring people at a more rapid rate than before because of the need to constantly train and because you inevitably will lose people, and you want to make sure that you're constantly training people who are gaining expertise in the area. That's the most important thing, is just have a core of qualified drafters who won't get burned out and be able to maintain a team structure so that if one person isn't available, it's not the end of the world. That's the other thing. When I first started, you were individual contractors. So this was your area and no one else worked on it because there's so few of us. So if you got slammed, and that was it. And they had moved into a team structure, which makes things a lot more bearable. But yeah, I think probably we still need to expand more staff. I mean, up until now, there have been budgetary constraints on that, but now they're realizing that, if you want to have enough staff to deal with the demand, which is continually growing, and the statistics show that, just in terms of the number of drafts that have to be produced, that you need to keep hiring and training people.
So the next question is, what book or article most shaped your thinking with respect to congressional reform, or even just how Congress operates? I guess I could expand the question.
Well, I can't answer that. But all I can say is that what I do is I like to read news accounts, analysis of what is happening in Congress or in the world, and then see if it comports with my experience of what actually happened. So sometimes I'd be in meetings and then I'd read an account of it, and it did not actually reflect what actually went on, but might get insights from editorial pages, things of that nature. But I don't think anything really has hit me over the head and influenced me to a great extent. I mean, I like to read, reviews, New Yorker. There's a great magazine called The Week, which takes those stories from all over the world and different viewpoints. And, so just you get that sort of viewpoint.
So last question is an easy one. Just what do you have in the plan? Are you working on any books? Are you teaching? What do you have coming? Well,
I'm still adjunct teacher. I like to do consulting work. I like to teach people how to draft. I'm a violinist, and I left that out of my bio. I started playing violin at age 7. And I play in a symphony orchestra, play chamber music, and I do solo recitals as well. So I do a lot of that. And, just trying to challenge my mind. But any opportunity, I just love to draft. So someone called up, I was drafting assignment, and I don't mind it. It's very intense, very time consuming. I just get in there, and so that's what I like about drafting. Everything's sort of like a little puzzle. This is what it is, and try to figure it out. And you figure it out, and then you figure out the words to do it, and nothing else. So when I got a letter once for a statute that I drafted, I didn't necessarily agree with it, but I got a letter from the chairman saying this is a bill that had language which has withstood extraordinary scrutiny. So I thought that can be my epitaph. She drafted language that withstood extraordinary scrutiny.
Fantastic. All right, Sandra, thank you very much for the time. It's been a pleasure. Thank you for your service to the country, and best of luck with your coming teaching and also the revision of the book.
All right. Thank you very much. Thanks for having me.
Thank you.